in that case, I'll hand over to Katie Broadley, who's going to give you a case law update.
Okay, so as Anthony said, I'm going to provide a case law update. I've picked up on 7 of the key cases from the last 12 months, and rather than go through the full details and bore you with all the little niggly bits of the cases, I've picked up on the key points for you, and I'm going to give you some lessons that should be learned for your business and some practical points to take away. The cases I've selected will cover employment status, some issues that would happen during employment, for example discrimination, and then I'll move on to dismissal. So we've sort of got the cycle of employment covered there. The first case that I'm going to cover is Stringfellows Restaurants and Koshi, and yes, that is Stringfellows nightclub. Miss Koshi was a dancer at Stringfellows for a period of 18 months. When she was dismissed, she brought a claim of unfair dismissal, and a key question arose. Was she an employee and entitled to claim unfair dismissal, or was she self-employed? The Employment Rights Act states that an employee is somebody who works under or enters into a contract of employment, and a contract of employment can be implied, express, oral, or in writing. Now, the tribunal found that yes, there was a contract in place. However, there was no written contract, and Stringfellows did not mean for there to be a contract in place at all. The key here is, do you have employment contracts in place? If you don't want one to be in place, consider whether there may be one implied. The key elements to look out for are whether there are mutual obligations between you and the employee, whether you have some level of control over them, and whether they're required to provide the work personally to you. If those elements are there, then it could be that there's an employment relationship. Make it clear and put an employment contract in place, or if you definitely don't want the employment relationship to be there, think about what other contracts you could put in place, for example, a consultancy agreement. The next case is Heathfield and Times newspaper. This case involves the busy newsroom at the Times around a time of a story that you may have seen in the news. It regarded the Pope and the allegations that he had protected a paedophile priest. There'd been some delay in producing the story, and there was a heated atmosphere in the newsroom, and one particular editor was very frustrated and irritated by the delay. He shouted across the newsroom, and excuse my language, "Can anyone tell me what's happening to the effing Pope?" He received no response, so chose to repeat the question across the room. Perhaps unsurprisingly, someone was offended. This individual was Mr. Heathfield, a Roman Catholic. He complained to the Times, however he wasn't happy with the way that complaint was progressed, and he brought a claim of harassment and victimisation on the grounds of his religious belief. The tribunal found that yes, there was unwanted conduct, but no. Mr. Wilson, who made the statement, didn't know that Mr. Heathfield was a Roman Catholic, nor was there any anti-Catholic purpose to what he'd said. Therefore, his claim was not upheld. The key lessons to take away from this case are that yes, there may not have been harassment or victimisation here, but there was disruption to the workplace because of these actions of the employee. There was upset and distress felt by this individual. So consider the level of control that you have over your employees and what they might do in the workplace. And also note that it's Times newspaper in this case, not Mr. Wilson. You're vicariously liable for the actions of your employees. The next case is Awida and others and the United Kingdom, and is one that, again, you might have seen in the news. It involves Miss Awida, who wished to wear a cross over her uniform when working for British Airways. British Airways refused and said it was in contravention of their uniform policy. Miss Awida brought a claim in the United Kingdom Tribunal on the grounds of discrimination on the basis of her religion. She was unsuccessful and brought a claim in the European Court of Human Rights, which is this present case. The key here is that is the act of discrimination justified? Well, British Airways said that their act was justified. Their uniform policy was in place in order to pursue a corporate image. the European Court of Human Rights said that no, that's not sufficient justification. By contrast, the case of Miss Chaplin, whose action was brought at the same time, involved a lady who wished to wear her cross over her nurse's uniform. The NHS argued that this was in contravention of their health and safety policy, and therefore that was sufficient justification, and the European Court of Human Rights in that case agreed. The lesson to be learnt here is discrimination justified? Is there an act or a policy that you've put in place in your company that could be discriminatory? And if it is, do you have justification for that discrimination? The next case, also on the topic of discrimination, is Selden and Clarkson, Wright and Jakes. This case involves compulsory retirement and age discrimination. Clarkson, Wright and Jakes, a law firm, had a partnership deed in place which stated that all their partners must retire at the age of 65. However, Mr. Selden did not want to retire, and when he asked to continue in his role, the law firm refused. He brought a claim for direct age discrimination, and it's worth noting here that direct age discrimination can be justified, but other forms of direct discrimination cannot be. So there's a slight difference in the justification point that I've raised. The tribunal found in favour of Clarkson, Wright and Jakes, and again the key was justification. Clarkson, Wright and Jakes had put forward legitimate aims to justify what they'd done, meaning put in place their compulsory retirement age. These included their desire to retain their current associates by offering them partner roles in the future, and also to be able to plan their business and their workforce and have realistic ideas of future vacancies. So the lesson to take away from this one, again, is that justification point I raised earlier. If you're going to put a compulsory retirement age in place, can you justify it? Do you have good reasons that justify your decision to? Not only justify the fact you're putting an age in place, but also justify the age you choose. We wouldn't actually advise that you do put one in place because, as we've seen, it's a little bit risky. But if you do choose to, it's best to try and seek advice before you do and put in place those justification reasons so that you're sure of them if ever you have an issue. Also on the topic of retirement is Quick and Cornwall Council. Miss Quick was a headmistress at a small school in Cornwall. Cornwall Council wished to merge this school with several other schools in the area, and because of this there were several discussions around retirement and redeployment of the teachers and the head teachers in those schools. Miss Quick was dismissed and she brought a claim for unfair dismissal on the grounds of her age. Key to her claim were allegations that her colleagues and senior staff at Cornwall Council had made comments regarding her age and her retirement plans and put those comments in writing. This claim failed, and the lesson here is that you can have some reassurance that you can discuss retirement plans in your company without fear of a discrimination claim being round the corner. Of course, you need to take care with any retirement planning and try and take a step back and think of how your employees might interpret your actions. Could they potentially be discriminatory? A third point to note is these notes that the individuals took. They were admissible as evidence. Think about what you're putting in writing and whether one day it could be before the tribunal. Next case on the topic of redundancy is Mental Health Care UK and Stilowen. The key to this case was the selection criteria that Mental Health Care, who ran a hospital, adopted. They were choosing, on the basis of this criteria, who to keep and who to make redundant, and they made 19 staff redundant. There were three elements to their criteria. The first, and the most heavily weighted, was a competency assessment, which was very much like one that they would use in a recruitment process, but not very common in redundancy situations. They also took into account sickness and disciplinary records, but as I say, the competency assessment was heavily weighted, and they also failed to look at any past performance of the employees. The results were very surprising, and Mental Health Care UK completely acknowledged that, but they went on to dismiss employees that they classed as being very good members of staff. They thought their process was robust and stuck with it. 2 of the employees they dismissed brought claims for unfair dismissal, and they won. The tribunal found that Mental Health Care UK had followed a blind faith process. They'd lost touch with fairness and common sense in trying to follow such a robust process. The lesson here is that redundancy is a very complicated process, and there's several legal issues that can crop up. Make sure you seek legal advice before entering into a process, especially if you've got 20 or more staff that are being made redundant, because there are extra regulations that are involved. Next, stick to convention. They tried to go left-wing and adopt a slightly alternative approach, and it didn't work for them. Wherever you can, try and stick to the norms and what's well practiced in the field. And finally, keep records of appraisals. The reason that Mental Health Care put forward for not taking account of past performance of their staff was that they didn't have sufficient records, so they didn't think that would hold up. Make sure that's not a problem for you if ever you need to hold a redundancy exercise, and make sure your appraisal records are really clear and kept in a safe place so they don't go walkabouts. And the final case I'm going to cover is that of Tye and Barchester Healthcare. This case involves dismissal on the grounds of gross misconduct. It involves a nurse who worked in a hospital, and she was responsible for one floor of that hospital and also several of the staff that she was supervising on that particular night when the general manager chose to make an unannounced inspection. This took place at 2 AM in the morning, and the general manager identified many health and safety issues. She also found that Miss Tye and some of her colleagues were asleep on shift, and it was later found out that Miss Tye had also falsified some medical records. An investigation followed, and then there was a disciplinary hearing, and Miss Tye was dismissed on grounds of gross misconduct. The tribunal initially found that yes, this was unfair dismissal, but on appeal it was reversed, and no, that wasn't unfair. The tribunal had made errors in their judgment, which the appeal discussed. The key issue here is that the tribunal's job in this case is to look at the band of reasonable responses that an employer might take as a result of gross misconduct. This acknowledges that not everyone will react the same to the same event. I could think one thing, my colleague could think another, but both our reactions are reasonable. So it's the band of reasonable responses that they're meant to look at and decide whether the act of Barchester fell within that. The tribunal didn't do this. Instead, they substituted their own view. They put themselves in the shoes of the employer and said, that was too harsh. They didn't do what they asked to do in the role of the tribunal, so the appeal reversed their decision, and they found that yes, it was the opposite, but no, it was not unfair dismissal. The key lesson here is that the tribunal shouldn't step into your shoes when assessing the case. They should look at this band of reasonable responses. So for you as an employer, the best bet is to try and take a step back and think about what other people might interpret as reasonable, and see whether you think it falls within the band of reasonable responses. There isn't a definite yes or no. It's whether it's within the band. And secondly, make sure you're clear about what gross misconduct is for your company. One of the problems in this case was that the disciplinary procedure that Barchester adopted was unclear, a little bit confusing, and that caused problems in this process. Make sure that's not a problem for you and have a disciplinary procedure in place, perhaps in your staff handbook, and make sure it's clear what you want to be gross misconduct and what you don't. Okay, so that's my summary of some 7 key cases over the last 12 months. As I say, I've gone through the key facts for you, and like Anthony, my handout has a lot more information in there for you, perhaps some bedtime reading if you're interested in all the extra facts. There's a lot more going on in these cases which I couldn't cover.